Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. So this series covers 4 fundamental questions, and today we are talking about the 4th, which is holding property and specifically shared estates today. So shared estates, what are they? They are present possessory interests in real property, which are shared between more than one person or more than one entity or some combination of people and entities. Shared estates can come about in any of the estates in land we discussed. Any of the freehold estates, fee simple life estates to feasible fees can be shared. Future interests can also be shared. Shared ownership typically comes about in one of 2 ways. You can divide the property as a whole into shares, giving, for example, 50% to person A, 50% to person B. People don't need equal shares in property. 3 parties could share, with one having 90% of the interest and the other 2 with 5% each. Alternatively, you can divide property into a Blackstonian bundle of sticks. So A might get the right to use, while B might get the right to exclude or to transfer. In general, when presented with property disputes, courts try to avoid shared ownership. So think back to the case of Pearson versus Post, covered in another video. It awarded a fox that was contested property to one party, even though both parties contributed to the fox's eventual capture and death. There are exceptions to the general rule that courts try to avoid shared ownership. One of those is Popoff versus Hayashi, which was considered in a different video. The case dealt with the Barry Bonds home run baseball, and the court awarded the ball equally to both parties because the court assumed that co-ownership would be temporary. And indeed, after the decision, the 2 parties collaborated to auction off the baseball and split the proceeds. Co-ownership is difficult and burdensome, even between intimately connected parties. It's a lot more difficult to transfer properties owned in common. There are administrative costs associated with co-ownership. And you might see the issue of waste arising more often in co-ownership situations where one party in possession does something to property the other would not like, or actually detracts from the value of the property. So nonetheless, despite some of these problems, individual parties still want to create shared ownership regimes. In some cases, parties may wish to share the costs and burdens of ownership. So think about a vacation home where multiple parties are using it. Parties who are co-owners are often intimately related. So think about a marriage. They feel some kind of bond. They want to own property together. Parties may also need to co-own property to acquire it to begin with, like you might see when somebody needs to co-sign for a mortgage. In other videos, we consider the 3 ways that people articulate this sharing of property: tenancies in common, joint tenancies, and tenancies by the entirety. But with that introduction to sharing property, I will leave it there. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list. See you next time.